Industrial 4.0 refers to the integration of smart technology into manufacturing and industrial process. And I'm very delighted to introduce this topic with IP today. And firstly, we are going to see why IP matters when we talk about Industrial 4.0. And we are going to discuss some relevant topics, IP types of Industrial 4.0, including patent, copyright, and trade secret. We are going to have a session about software. Industrial 4.0's technologies include hardware and software, such as AI, robotics, blockchain, and big data, and that requires massive research and development investment. If you already have an IP to protect those technologies, that means you will have the exclusive right to use your IP in China. And without your authorization, nobody else can use your technologies. And with the IP, you will also generate revenues because that IP is cutting-edge technologies. You can license them. You can collect the royalties from those technology. And with the extra revenues, you can reinvest to your technology and develop it to a further level. If you have a strong IP protection, it's more likely that it will attract more partners and investors. If you already work with Chinese companies, you may realize they value IP more and more these days. They prefer to work with European companies who has stronger IP portfolio. That means the risk of infringing others' IP is lower, so it's safer to go with European companies with stronger IP portfolio. And of course, the IP also can prevent your competitors from using your technologies without your authorization. And in terms of the infringement, you will be able to take actions against them instead of doing nothing but let other people to exploit your IP. To understand the IP landscape in China, there are three very important principles you need to keep in mind. The first is registration that applies to trademark and patent. Without the registration, your IP, trademark and patent will not be fully protected in China. For the other types of IP like copyright, you don't need to register it, but it's recommended to do it because it will be helpful for you to enforce your rights. And as you may know, trade secrets, it's not registerable. And second principle is that IP is territorial right. If you already have IP in Europe, in Bulgaria, that doesn't mean you have IP protected in China. If you have international IP like patent, industrial design, or trademark, making sure that IP is extended to China before you sign any contract or do any business with Chinese company. And the third principle is first to file. In China, if whoever is the first to file the trademark or patent, they can claim they are the owner of their IP. So if you are not the one who firstly file the trademark of your brand or patent of your technologies, you may face the risk that losing your IP. It's still possible to claim back, but it will take a lot of time and money to do so. Therefore, we always recommend to assess your IP, audit your IP, and register it, protect it in China as early as possible. And the IP types in China are very similar with Europe. So we have patent, we have trademark, copyright, and trade secrets. For patent, different from Europe, there are three types of patent. We are going to explain the details of the difference among these three types of patent more later on. But keep in mind that industrial design in China is also one of the patents. That means you have to register it in China to get the protection. In Europe, you can choose not to register it, but in China, without registration, without protection. For trademarks, trademarks protect the brand name, brand logo, and Because you are in the China market and the Chinese still the most common language. The average Chinese may not understand English very well. So you should consider to decide the Chinese trademarks for your brand before coming to China. That will help you to brand your products, brand your companies in a more successful way. And for the copyright, it protects the software, logo, brochure, video, everything you can think of as an artwork. And copyright in China is automatically protected if it is created in Europe. However, different from Europe, there's a registration procedure in China for copyright. We recommend you doing that because the copyright registration certificate is very helpful for you to enforce your rights. That includes software, that also include industrial design. And for the trade secrets, as long as those sensitive business information is non-public, the public is not aware of that, and it has actual commercial value, and there is evidence that you already take measures to protect those business information as trade secrets, then those information could be regarded as trade secret. That is a very important IP for technology companies. I already mentioned there are 3 types of patents in China. For invention patent, it protects the new technical solution or even the improvements of your previous products or process. It protects the function of the technology. And it lasts very long, like 20 years in China as the protection term. To get the registration and full protection, you can file the application either in China or via the World Intellectual Property Organization. And it takes quite long to get the registration. Therefore, if you have new technology and decided to target in the China market, you should start it as early as possible. The average time to get the invention patent is 3 to 5 years. As you can see, it's quite long. And the official fees to get it, it's around 400, it's above 400 euros. That's only for the official fees. As a European company, you need to hire a Chinese lawyer to do that for you. And this price, it's not included the lawyer's fee. And the second type of patent is utility model. Again, it protects the function of the technology, mostly physical products. It protects the functional shape or structural physical feature. And the protection term is rather short. It's only 10 years. So we also call it shortened patent. And the examination is very short. It's only half a year. So you can register it very quickly. And it only takes 60 euros to get this registration. Design patent protect the aesthetic part of the products. It doesn't protect the function of the products. And the protection term lasts for 15 years. It takes very short time, like half a year to get the registration. And the official fees for it, it's only 60 euros. Just an example to help you to understand the difference between those 3 types of patent. For storage battery, which is commonly used in EV, nowadays. If your storage battery has the new solution, that means this new management system allows the battery to work in a more efficient way. For that new solution, you can decide to patent it as invention patent. And if the battery has the structure to reduce the temperature, that's the functional structure, then you can consider to use utility models to protect it. For the unique shape of the battery, not necessarily related to the function of the battery, you can patent it as design patent. As you can see, one product, you can use multiple patent application to protect it as comprehensive as possible. To start the registration procedure for patent, you can choose either the national routes or international routes. The major difference between those is how you start the procedure. The national routes means you directly filing with the Chinese authority. The full name is China National Intellectual Property Administration, CNIPA. And if you get it registered, the protection only extends in China, not in any country. Keep in mind that for all the patents, you have to make sure you applied before it's published in the market, not only in China, but also the rest of China. But there are some exemptions of this principle of absolute novelty. If you attend international trade fair, sponsored or recognized by Chinese government, for instance, China International Import-Export in Shanghai, that's the biggest one in China. And after the publish of your technology products or software, it's still possible to file that patent within 6 months after you showcase in the trade fair. And for most of the European companies, when they apply patent in China, they will usually choose the Paris Convention, that it's the priority claims. That means if you already have patent applied in Europe within 12 months or 6 months, you can extend to China. 12 months is for the invention patent and utility model. 6 months it's for the industrial design. As you can see, the timeline to apply for patent is essential. If you are not sure whether or not you can choose to patent it in China, confirm with me or confirm with your patent attorney. The second route is the international. Because China is a signatory of international treaty, that means you can use the international route to protect your technology in China and also in Europe, in US, and most of the major markets around the world, depending on your business strategy. And when you choose the international routes, for different types of patent, you go with different application. For invention patent and utility model, you go with PCT. For industrial design, you go with the Hague system. The industrial 4.0s most of the time include software, database, AIGC, and algorithms. Those are the very valuable information, very valuable assets for the companies. When we talk about that, the most common way to, in IP context, is to use the copyright to protect them. For software, the source code of the software can be copyrightable. And just keep in mind that the source, because the copyright protects the expression of the idea, not the idea itself. So if someone changed the coding libraries, but using different source codes, it is not copyright infringement. Therefore, for software, copyright protection sometimes may not be enough, and you have to seek for other protections such as patent or trade secrets. But the software copyright is the easiest way to protect your software. And later on, we will explain how to register your software as in the copyright system in China. Second common technology to be copyrightable is algorithm. Algorithm, most of the time, it's regarded as an idea. That means it's not protected by copyright. However, if the algorithm is integrated into the source code of the software, then it could be protected by copyrights. For the database, it's a collection of the data. The data itself may not be able to protect it by copyright. However, if there's any intelligence efforts, human beings' intelligent efforts to put into the database, that means that it's a compilation works. What does that mean? That means for a collection of data, if you arrange that in a way that adds the value to the data itself, then it could be protected by copyright. Just an example, for the database, including all the information of the website users or any product user, it seems there's no organization, but if you organize that according to time or region, then this database becomes valuable and you don't want anyone to steal this from you. In that case, you can consider to use copyright to protect it. And the last one is the most debatable one around the world. It's the AI-generated content. In China, it's also still in debate that whether or not it could be protected by copyright. However, even though the practice and the judges in China, the case laws in China are very different, but it's mostly likely that if your content is fully generated by AI, the author it's not you, it's the AI, then that content is not protected by copyright. On the other hand, if there's any human beings' efforts put into the contents, for instance, like AI assistant content, AI generated art edited by the human beings, or AI assisted writing with substantial human revision. You can see human is involved in the whole creation work. Then it could be seen as the expression of the author's original creative content. In that case, it's possible to use copyright to protect it. However, again, I have to mention all these 4 types, especially the database AI, GCN algorithms. It is case by case that it could be protected by copyrights. If you encounter any infringement, the judge will still make the final decision whether or not it can be protected as copyright. And the copyright is automatic protected in China. And it's important for the enforcement. It takes rather short time to get the registration done, because in China the authority will not check in a detailed way. They only check the formality, the documents you file, whether or not they are qualified. And for the software, it takes a little bit more time, 60 days, to get the copyright register. But software is free to register. And the protection term is 50 years, depending on its individual or companies, but at least 50 years. Like I said, the source code of the software can be protected by copyright, but the core idea behind that, it's not protected. Therefore, consider using copyright and trade secrets or patent to protect your software. When you consider registering your copyrights, including software, there are 2 options for you to do it. First one is to register with the Chinese authority, Copyright Protection Center of China. And the procedure is very straightforward. You open an account and file all the documents, and then the certificate will be issued. If you do not have Chinese employee, or you don't have the Chinese companies branch, I will recommend you to consult with the IP experts or IP lawyers to help you to process it. And the second registration option is to use the blockchain technology. The advantage of using this blockchain technology is to notarize those evidence that you create this software, you create a database at any time, anywhere. And you don't need to hire a lawyer to do that. You can do it with your own blockchain technology, or with your own phone or computer embed with the blockchain technology. And it's quite cheap. Most of the time, it doesn't cost you any money. And in terms of the platforms, there are many platforms you can choose from. Those 2 are the most common used one in China by the IP lawyers. This is just for your reference. And besides patent, besides software copyright, another important types of IP is trade secrets. You have to take measures to protect those sensitive business information as trade secrets. And here are 5 steps of the measures you can take, but this is not an exclusive list. If you think of anything else, you can always add in more here. First step is to identify and catalog your trade secrets. And second, use the combination of different barriers, including physical, technical, and contractual, to protect those trade secrets, and document what measures you already take. In case there's a dispute later, you have to use those evidence to prove this is your trade secret. And implement the protection policy within your company, also with your partners, making sure your employees understand your expectation. And lastly, you should consider signing NDA even before entering the negotiation with the third party. And a lot of companies come to me and ask whether or not this Chinese company is decent and how to select a good Chinese company. This is a very important step before you decide to come to China or work with Chinese partners. Because if you choose the wrong partners, it's possible that you put your IP into risk. They could steal your trade secrets, or whatever information you share with them, or even infringe your patent, your technology, of your technology. So how to make sure this is the good Chinese business partners? And there are many ways you can choose from, but this is the more commonly used way, and and this is the step you should take to do the due diligence on business partners. How to do it? You can use the Chinese official database called National Enterprise Credit Information Publicity Systems. However, this system is only in Chinese. If you don't know Chinese, then it might be difficult for you to use. You can always contact us or the embassy or Chamber of Commerce in China to help you to use this database. And you can also refer to here, it's our step-by-step guide. It's a very simple video to help you to use this database. And from this database, you can learn some basic information such as the legal representative. That should be the one who will sign the contract with you later on. So it's important to know who is that person. And also capital of the company, business type and date of establishment, shareholder, those basic information you can access immediately. You can also learn some more advanced information, include whether or not this company is in a normal operation. If your potential Chinese partner is already bankrupt and they shouldn't be doing any business with you. You can also check if they have any history of disputes, such as IP infringement or breaching the contract with previous partners. So you can evaluate whether or not you want to work with them. And the last thing you can access is the annual reports. Many companies may want to track the revenues of Chinese company from the annual report. However, this is the information most of the companies choose not to reveal. So you may be not able to read the revenues information from this database. Another part to help you to avoid a trade secrets infringement is to properly handle the meeting with business partners. Like I said, before the negotiation or during the trade fairs, you have the intention to work with these partners, and you should consider asking your Chinese partner to sign the NDA before you share any information with them, and making sure you do the background search, the due diligence I already told you, before going to the next step. And when you share the information, at a very early stage, making sure you only share the general idea or rough sketches of the technology or plans or drawings. You can always invite them to view a more detailed information at your premises, not in their offices. And when the business negotiation reach at a certain stage, you can send the MOU that outlines the structure of the deal and what information you are going to share. And again, making sure it includes the non-disclosure obligation of both parties. And in the final agreement, you should identify in a more detailed way, like who owes what IP, what information, and what information was going to exchange during the collaboration. And again, the non-disclosure obligation of both parties should be included. After you sign the contract, you should continue to monitor your partners. And in the contract, you can also include that you are allowed to pay unannounced visits to the Chinese plants. That will give you a better view of whether or not the Chinese partners follow your instruction or follow what you expect them to do. And lastly, I want to discuss about the software. So in software protection in China, I mentioned several times that software can be patented in China, that it's different from Europe. As long as the software solves a technical problem, use the technical means and achieve a technical result, it could be patentable. And because software patent is in China for quite a short time, compared with other traditional patent, and there are not the rules and laws still developed to catch up with the technology development in China. However, according to the latest rule, there are 4 types of software you can consider to patent in China. Not all of the software can be patented. First one is the computer programs for industrial process. Just an example, if a method of controlling a rubber molding process use a software to enhance the quality of the product greatly, you can see there's a technical solution. The quality of the products can be enhanced after using this software, then you can consider to patent it. Second one is the software to improve the internal performance of the computers. If a software solution is to expand the storage capacity of computer using a virtual device file system, then that software you can also consider to patent it. For the software to control for the software including or functioning as controlling, measuring, testing process, you can consider using that as well. Just an example, it's quite a common one. That's the technology uses a computer program to analyze the signals from the sensor and measure the humidity of the air in a more accurate way and a more quicker manner. Then you can consider to patent that software. The last one is the software to process external data. You can consider to patent it as well. However, this is not a very clear or certain in the practice. When you have this software, I always suggest you to consult with a patent attorney in China to discuss with them and to come out with a good strategy to use different IPs to protect your software. And the most important thing is to see whether or not your software can be patented in China. And for those unpublished data, source code documents, you can also, of the software, you can also consider to protect it as trade secrets. Again, all those steps are very similar with the general steps I shared before. Like you can categorize the business information as confidential and control the accessibility of important documents, making sure those employees who can access to those documents has to be based on the need to know. If they need to know, they can access it. If they don't, then do not allow them to read those documents. And implementing robust IT security infrastructure, implementing a trade secrets protection policy, especially with your employees, and regularly review the external communication and signing the NDA or even some or the non-compete agreement with your employees. There's a lot of agreements you can sign as long as you can think of any. And we talk about patent, we talk about trade secrets, we talk about copyright. There are still some other IPs we should not ignore, like the trademark. For the name of the software, you can trademark it in China, come out with a Chinese name for your software brand, and keep in mind that a lot of European companies already encounter bad faith registration. That means they do not even in China, but their trademark already been stolen in China. That's very common. In that case, you should register your trademark in China as early as possible, especially for the brand name of your software. But please do a trademark search before registration. You can contact me to do the trademark search, or your patent attorney who works in China. And if you have a graphical user interface, you can always register as industrial design. That's similar with how it works in Europe. I want to share 2 case studies for you to understand how European companies tackle the difficulties in China, especially when they work with IP system. The first case study is about the importance of well-drafted patent application. Well, there's a European SME that developed an innovative technology consistent of a pixel array of contactless input panel. And the SME already filed a patent application in China. However, it was rejected by the Chinese authority because the CNIPA, they think this invention only provided a specified construction of a pixel array, and it does not constitute a technical means. It doesn't solve any technical problems, so they couldn't tell what its technical effect the invention can achieve. According to the patent law, it is not patentable. The SME is not satisfied with the result, so they file a review before the court. And the court found that the user of the SME's new technology could input information through the panel without contact. That it's what contactless mean. And it was created to solve a technical problem, that's a contact panel being easily damaged under pressure. So eventually, the court reversed the CNIPA's decision, and these SMEs successfully registered their patent in China because their invention actually include technical solution. So from this case, when drafting a patent application, it's important to connect the concerned invention with a technical scenario. So you can make it easier for the examiner to understand the technical problem solved by your invention. And if the description of patent is based on known technical effects, such as efficiency, speed, reliability, those language is easier for the examiner to understand, then it's more possible that your patent will be accepted. And again, it's recommended to use the IP patent attorney in China when you try to protect your technology as patent in China. The second case study is about trade secrets. For these European SMEs, they work in chemistry industry. They license the know-how, including software, to Chinese companies to help them to build up chemistry plants. And in the license agreement, first, before signing the agreement, they do the due diligence, and they decided to work with a Chinese company who is on the very top of the industry. So they think this company will be reliable. And besides the license agreement, they signed a separate agreement just to handle the IP enforcement. In the agreement, the European company authorizes their Chinese partner to handle the enforcement in China because the Chinese party always has more resources to deal with the IP infringement in China. And to protect those business information, they take measures to protect. For instance, all the technical documents are delivered using double strong encryption, with triple encryption used for key equipment. And only the employees who needs to know can access to those important documents. And the technical documents contain hidden markers that identify them as IP as well. Unfortunately, infringement still happens. 2 former employees in key position in the Chinese companies stole the confidential documents and sold to a new plants in other provinces, and the SMEs and their Chinese partners decide to take enforcement. First, they file a complaint with the police, where the former employees was located, and very common to ask for help from the police when you encounter the trade secrets infringement. They have more power to help you to invest and collect the evidence. The police start the investigation, they obtain the drawings of the plan, and they even hire an expert witness to do the comparison of the drawings of the SME and the drawing of the new plans, and confirm that it is trade secret infringement. And later on, the police issue a countrywide warrant to search and arrest those two former employees. Up to today, one of the employees was arrested. The other one is still at large. And the new plant still proceeding with the installation and now has commenced production. That brought larger loss to the European companies. And the SMEs file a criminal complaint in Europe member states. Probably, hopefully, they will involve the International Criminal Police Organization. They also contact the embassy in China and Chamber of Commerce to see what other resources they can use to solve their IP infringement case. This is rather a complicated infringement case. From this case, what I want to say is you should take various measures to protect confidential business information as trade secrets to make sure the prevention measures is important. And the leakage of the trade secrets by former employees is the most common way when we talk about trade secrets infringement in China. And signing the agreements to protect your confidentiality as much as possible. And it's not cheap to enforce IP in China. It can easily go to beyond Europe's 10,000. However, if you do not stop the first IP infringement, it will attract more infringements in the future. So taking the first IP infringement seriously and talk with the IP experts. And lastly, I leave some takeaway messages. Audit your IP assets and obtain IP protection. For trademark and patent, no registration means no protection in China. Even though copyright is automatically granted in China, you should consider copyright recorder and consult a patent attorney before patenting your technology. Taking various measures to protect confidential business information as trade secrets. And if you unfortunately encounter IP infringement in China, consult with the IP experts or contact with us. You can always book a consultation with me. This is free of charge. We can discuss all IP topics you want to discuss about, like how to register trademark and how to make sure your Chinese company, your Chinese partner is decent to work with. There are two ways to book the consultation, either scan the QR code or go to our website. And you can find China IP SME Help Desk in different channels. And lastly, it will be much appreciated if you can scan this event feedback form and let us know your thoughts of today's training and what topics you want to discuss in the future and how to improve our services. Thank you very much.